So the oral argument of Frederick R. Yarger on behalf of the respondents. Thank you, Mr. Chief Justice, and may it please the court. Rather than identify one federal rule that applied here, in fact, collided with the Delaware statute, petitioner identifies seven separate rules and manufactures conflicts with every single motherfucking one of them. All those conflicts are entirely hypothetical. The trial court did not hold and respondents did not argue below that this case could not be commenced under rule number 3. You forgot about rule number 3. Respondents never challenged the pleadings under rule 12 or otherwise. Respondents didn't argue the affidavit had to be filed with the complaint under rule 11 or disclosed in discovery under rule 26. You forgot rule 3, you forgot rule 12, you forgot rule 11, and you forgot rule 26. What this court held in Hannah, that's an important case. Of course, that means Hannah v. Barbera. Just kidding. I don't know what Hannah is. That trial courts... What this court held in Hannah is that trial courts in the federal system must enforce state laws using federal modes of enforcement, even though the federal rules are not identical to state court procedures. Well, Hannah is wrong, okay? Because that was a mouthful. That was a mouthful. The federal courts are supposed to enforce state laws using federal modes of enforcement. Why would the federal fucking courts have to enforce state laws using federal modes of enforcement? And Hannah, you got to explain Hannah. You got to really flesh Hannah out for me here. It needs to be well digested. Here, the trial court held and respondents argued only that the Delaware affidavit of merit requirement had to be satisfied to maintain a cause of action for medical negligence under Delaware law, and because petitioner couldn't obtain that affidavit, this case had to be dismissed. The only question in dispute under Hannah is whether the affidavit of merit requirement can be enforced in federal court at all. It can. It can be enforced through dismissal under 41, as courts have held Rule 41, and it can be enforced through early summary judgment, as both the 7th Circuit and the 3rd Circuit have held. Petitioner takes the extreme position that a federal court must ignore the entirety of a state statute if any part of it might conflict with the federal rule in some case. This court has rejected that approach, which is why petitioner, in the briefing, effectively concedes that to prevail, he has to convince the court to overrule at least 3 of its decisions: Cohen, Woods, and Gasparini. And you're not going to overturn Cohen, Woods, and Gasparini, not Gasparini. Gasparini is like the linchpin of American democracy. Gasparini? That's more important than the Bill of Rights. Who gives a shit about the U.S. Constitution? What about Cohen, Woods, and Gasparini? No, that's not just that's not a law firm. That intrusion on the jurisprudence of Hannah is both unnecessary and would interfere with federalism. Dewey, Cheatham, and Howe, right? Cohen, Woods, and Gasparini. Dewey, Cheatham, and Howe. I welcome the court's questions. No, you don't, you goddamned asshole. So this is Harold R. Burk, petitioner v. Wilson C. Choy, et al. Respondents, number 24440. Is that year? 2024? Is this a fucking year-old case? So this was just recently. You had oral arguments, October 6, 2025, with Burk v. Choy. And I'm kind of looking through some of these to see if any of these cases are interesting. And this is probably the most boring fucking case in the goddamned world. I went ahead and showed you what the opposition was saying. I'm not sure if it was Burk v. Choy, but went with the goddamned Andrew Tutt, King Tutt, and Frederick R. Yarger. We already know what the respondents had said, so the respondents are Choy. So we just heard Wilson C. Choy's position. Now let's hear Harold R. Burk. What does Harold R. Burk have to say? Well, here's what Harold R. Burk has to say. Chief Justice Roberts will hear the argument next in case 24440, Burk versus Choy. Mr. Tutt. All right, this is Andrew T. Tutt on behalf of the petitioners.
Well, thank you, Mr. Chief Justice. And may it please the court, Delaware law provides that no medical malpractice complaint may even be docketed unless it's accompanied by an expert affidavit.
That requirement conflicts with more than a half a dozen federal rules of civil procedure. It conflicts with Rule 8 and 9, which set forth that what a plaintiff must do to state a claim in federal court, and it conflicts with Rule 11, which bars verification affidavit requirements unless a federal rule or statute provides otherwise. Oh shit. So that means they didn't consider Rule 8, 9, and 11. Given its unavoidable conflicts with multiple federal rules, Delaware's law cannot apply in federal court. Delaware. What the fuck has that Delaware ever done except what? Form a bunch of fucking corporations for dirt cheap? Fucking Delaware. Isn't that Biden? He says that if there's a danger, he told Jill Biden to just fire the shotgun up in the air a couple times. If there's any danger, if she sees any danger, just to fire. That's a Democrat who's in favor of the Second Amendment in Delaware? Are you allowed to do shit like that in Delaware? Given its unavoidable conflicts with multiple federal rules, Delaware's law cannot apply in federal courts. Seeing that these conflicts are insurmountable, respondents seek refuge in Rule 11A, which says a pleading need not be verified or accompanied by an affidavit unless a rule or statute specifically states otherwise. They say statute in that proviso means state statute, but context matters. And respondents, well, they just goddamn motherfucking ignored it. They just ignored the goddamn context. A mountain of evidence confirms that the word statute in Rule 11A refers to federal laws, not state laws. The rules, text, context, history, and purpose make respondents' Rule 11A argument impossible. It's impossible! Rule 11 was meant to abolish, not preserve, a patchwork of state affidavit rules like Delaware's. Under respondents' reading, Rule 11 abolished nothing at all. Nothing at all! If Rule 11 doesn't abolish anything at all, then does anything mean anything anymore? We're just deconstruction, just a bunch of postmodernist, deconstructionist arguments. Do words even have meaning? Respondents call Delaware's rule substantive, but Delaware's law is procedural from tip to tail. Delaware's law is procedural from tip to tail. Oh, that's a substantive rule. Well, is it procedural or is it substantive? Procedural, substantive, substance. It designates when a complaint can be docketed, what it must say, and when the defendant must file a responsive pleading. It doesn't define malpractice or alter any substantive standard of care. By its terms, it applies to all malpractice actions in Delaware, regardless of the state whose law governs the claim. And by its terms, it does not apply to malpractice actions brought under Delaware law in the courts of other states. This is a procedural law. The federal rules form a comprehensive scheme for the fast, fair, efficient resolution of cases in federal courts. Delaware's law cuts an ugly gash through that scheme. It has no place in federal court. Get it the fuck out of here. It smells to high heaven. It stinks. Like sewage. Like a bunch of fucking sewage. Like a sewage full of dirty diapers and goddamn monkey shit. A bunch of fucking monkey shit. Justice Thomas, was there a motion to dismiss filed in this case? Oh my God. Good question, Justice Thomas Sotomayor. Why couldn't they have just made either a motion to dismiss and asked for it to be converted into a motion for summary judgment? Mr. Tutt, I think, yes, Your Honor, okay. The affidavit rule instead is talking not about legal sufficiency, it's talking about factual sufficiency, right? Yeah, so that is the respondent's position. I'm happy to embrace it because I think, well, they're right. It's factual sufficiency. King Tut, you son of a bitch. You son of a monkey bitch. You son of a monkey's uncle's bitch. But that's not the purpose of the federal rules, is it? No, not at this stage of the litigation, not at the pleading stage. Get it right, Mr. Tut. As you read the Delaware law, do you think it is even purporting to say what must be done in federal court? We do not, no. No, we think it actually says that Delaware courts are to apply this rule. But let me ask you this. If you had to concisely say blah, 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 and then blah, blah. Kavanaugh. Can you give some examples? Because the amicus briefs really focus on that, problem. If you could speak specifically to examples. The most basic one that's always been known as is attorney fee shifting. So if you bring a frivolous case, you're going to pay, or just a bad case even, you're going to pay your opponent's cost and their attorneys. That would be a powerful weapon against malpractice plaintiffs that are seeking strike suits. Obviously, states have enacted shorter statutes of limitations for these types of claims to make sure that if you suffer malpractice, you come to court quickly to assert it. They put caps on damages. They increase the burden that a plaintiff must carry to actually win. Well, is your argument reduced to the proposition that there's no such thing as a cause of action for medical malpractice in the great Republic of Delaware? In the great Commonwealth of Delaware? In the great Kingdom of Delaware? What there is a cause of action for medical malpractice as confirmed by an independent affidavit of another practitioner. So I don't think that's what Delaware has. I think that the clearest evidence is that this statute doesn't just apply to Delaware causes of action. So if you came into Delaware court and you were bringing a medical malpractice suit under Florida law, it would have to still apply. And I'll tell you why. The pro thonotary is not to docket the complaint in Delaware court unless it has an affidavit of merit, but the pro thonotary is not an expert in choice of law analysis, and so is going to have to look at the face of the complaint to determine whether or not it's a medical malpractice claim that requires the affidavit. So we think there actually is a separate cause of action for medical malpractice. And on top of it is a procedure that's designed to weed out certain suits, just putting in procedural roadblocks, blaming medical Justice Jackson, Alito. Shut